Okay, we are streaming live via YouTube. Deputy, if you were bringing forward defendant Patrick Allen, that will be the first hearing of the day. I'm officially calling the state of Georgia versus Patrick Allen, specifically warrant number 2022 CW 55803 for the charge of simple battery. And are you handling that case, Solicitor Brooks?
I am, Your Honor.
Okay. The state will be represented by Solicitor Charles Brooks, and the defendant will be represented by Attorney Jay Kim, correct?
That's correct, Your Honor.
Okay, we're just waiting on the defendant to be brought forward.
Officer Chrome, if you would activate your camera and microphone.
Okay, we are ready to get started. Solicitor Brooks, your witness.
Thank you. Officer, if you would raise your right hand. Do you swear affirm testimony about giving a matter now pending before the court be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Tell us what's your name for the record.
My name is Officer Crum, Lovejoy Police Department.
And what, how do you serve the Lovejoy Police Department?
I'm a certified peace officer.
Are you assigned to a particular division or unit of police department?
No, not entirely. I'm just a regular police officer as well as a hype unit.
Okay. And is it part of your duties and responsibilities as a general uniform patrol officer to respond to 911 call outs?
Yes.
Do you recall responding to an incident on December the 29th of 2022 at 2426 Brianna Drive, Hampton, Georgia?
Yes, sir.
Is that here in Clayton County?
Yes, sir.
Do you recall what that call out regarded?
Yes.
What was the nature of the call out?
It was a domestic violence call.
And when you responded to that call, did you encounter one Patrick Allen?
Yes, sir.
And ultimately, did you conduct an investigation to lead to charges?
Yes, sir.
Would you recount for the court the nature of your investigation that led to those charges?
Pretty much the offender, he stated to me that he was punched for no reason by his roommate. I had two witnesses, including the victim, which they both stated that Mr. Allen rushed/charged at him using both of his hands while screaming profanity language at him. And then
so let's be a little bit more specific. Okay. On incident date, I think we said December the 29th of 2022. When you arrived on scene, who did you first find?
I first found Mr. Allen.
Okay. And when you is he the first person that you spoke to as well?
Yes.
Okay. After learning from him, and I think you said that he said that his roommate punched him for no reason.
Yes.
Okay. After speaking with him, what did you do next?
I then I see if he needed any medical attention. After that, I went to the other roommates that was inside the residence to speak with them.
And how many roommates did you identify related to Mr. Allen?
There was two.
Okay. And of those two roommates, were you able to identify them?
Yes.
Okay. Who did you identify?
One was Miss Leolandro, can't even say it. Miss Leolandro and Mr. Roberto.
Okay. And after, did you speak to both of them?
Yes.
And speaking to both of them, what did you learn?
I learned that how did the incident occur in the first place, and to leading what Mr. Allen first previously stated to me, which was that they both stated that Mr. Allen rushed/charged at him, and that's when Mr. Roberto swung at him in self-defense.
And Mr. Roberto, did you learn during the course of your investigation that he feared that Mr. Allen was going to tackle him?
Yes.
Is that the reason he swung at him?
Yes, that's the reason.
Is there anything else of evidentiary value that you learned during the course of your investigation?
No, sir.
Ultimately, at the conclusion of your investigation, what did you do?
I'm sorry, can you re-advise that question?
Yes, ma'am. At the conclusion of your investigation, what did you do?
I ended up taking a warrant out for Mr. Allen's arrest.
And what was the warrant for?
It was for a simple battery.
And the parties, did they all live in the same household?
Yes.
Okay. And did you pursue simple battery family violence because of the nature of how they lived?
Yes, being that they all lived in the same residence.
Okay. No additional questions at this time.
Okay, your witness, Attorney Harvey Williams.
Your Honor, this is my case.
I'm sorry, Attorney Kim, sorry.
Yes, Your Honor, thank you. Ms. Cribs, I represent Mr. Patrick Ellen. I had a couple of questions in regards to what you had just stated. So on December 29, 2022, you responded to 2426 Brianna Drive in reference to domestic disturbance. Is that correct?
Yes, sir.
Okay. As part of being an officer, part of your job, I believe, is to write a complete and accurate report, correct, based on your investigation?
Yes.
Okay, fantastic. In your police report, do you recall putting that Ms. Leonard had stated that Mr. Marrero pushed Mr. Allen away because Mr. Allen was coming at them like he was about to attack them?
I do not recall.
So you don't recall putting in the police report that Ms. Leonard had stated that Mr. Marrero had pushed Mr. Allen because he believed Mr. Allen was about to attack him. So you don't recall that?
Yes, I'm sorry about that. Being that you jogged my memory, because she witnessed him doing that. She's a witness in this case.
Okay. Ms. Leonard never stated to you, because if she did, it would be in the police report that Mr. Allen had actually made physical contact with Mr. Ribeiro. Is that correct?
I'm sorry, read about that?
Yeah, sure. Sorry about that. So did Ms. Leonard ever state to you that she observed Mr. Allen physically make physical contact with Mr. Marrero?
Yes, she did.
Okay. You would have included that in the police report, isn't that correct, though?
Yes, however, what I did say is that she stated when they went upstairs that she did observe him coming at Mr. Roberto when he was coming to attack, like he was about to attack them. So they was together.
So when you're saying about to attack him, so Miss Leonard never actually observed Mr. Allen make physical contact. Is that correct?
Let me correct my statement. I'm sorry to the court. I stated that in my police report that she observed him pushing Mr. Allen. Mr. Allen actually pushed Mr. Roberto. I'm sorry to the court. Okay, Ms. Alina, which is the other witness, stated that Mr. Allen charged at him towards Mr. Roberto. And
Sure.
she did state that she did saw him because she was able to write that written statement and when she observed him do so. So when I said attack, he was about to attack them, she was in referencing to Mr. Roberto.
Mr. Roberto attacking Mr. Allen?
No, Mr. Allen attacked Mr. Roberto by charging at him, rushing at him.
Okay, but when he's attacking in regards to charging, was there any physical contact that Ms. Leonard stated? Or?
It was no, Mr. Leonard did not say any physical contact, but she did say that he was charging at him.
Okay, so you would agree that charging at someone doesn't mean that there's physical contact, correct?
I would agree that, but however, it's provoking.
But you understand what simple battery requires?
Yes, I do. Yes, it says either or.
Okay. Additionally, let me see. In the police report, I believe you had put that Mr. Marrero stated, give me a second. Sorry, one moment. So earlier you said that you believe Mr. Allen was the primary aggressor.
Yes.
Is that correct? And that was part of the reason why you ended up arresting Mr. Allen, correct?
Yes.
Okay. Earlier on, you stated that the two witnesses have recounted that they had followed Mr. Allen to his bedroom. Is that correct?
Yes, it was Mr. Roberto who followed Mr. Allen and what he stated to me.
Okay, could you tell me what Mr. Roberto had told you as to why he followed Mr. Allen?
He said it in order to tell him about the nature of not saying anything up to his child.
Okay. So Mr. Roberto ended up following Mr. Allen, correct? However, you ended up arresting Mr. Allen for being the primary aggressor. Is that correct?
Yes.
Okay. Give me 1 second. So in your police report, you had also provided that Mr. Moreno then stated Mr. Allen turned around, rushing, charging at Mr. Morero with both hands out, screaming, "Don't call me a bitch." Mr. Morero stated he swung and hit Mr. Allen in the face because he felt he had to defend himself from Mr. Allen. So did Mr. Morero at any point tell you that Mr. Allen had made any physical contact toward him?
Physical, no.
Okay. No further questions, Your Honor.
Okay. Solicitor Brooke, do you have any redirect?
No, ma'am.
do
But
you
we
have-
do have opening argument.
Okay. Okay. Do you mean closing or you said opening?
We reserved right to open and close, Your Honor.
Okay. Okay, Attorney Kim, do you have any witnesses?
No, Your Honor.
Okay, well, we're ready for argument.
Yes, ma'am. Your Honor, based on the evidence that the officer provided, the state does not believe that there's sufficient evidence for a simple battery family violence offense. However, there is sufficient evidence for to charge a simple assault. The testimony that the officer proffered was that Mr. Allen charged at an individual she identified as Mr. Roberto, causing Mr. Roberto to believe that that he was going to be tackled and that he needed to defend himself. Is the reason that he swung, per the officer's testimony. With that, Your Honor, the state asked the court to bound over the charge as simple assault, which was the proffered evidence that the officer provided during the course of the hearing.
Okay. Okay, Attorney Kim.
Yes, Your Honor. Your Honor, as Officer Kroom had testified in court, I don't believe there is sufficient evidence in regards to the simple battery. Officer Kroom, on the day of the incident, had taken out warrants for simple battery. Based on her testimony, I believe there was a poor investigation done in regards to the disturbance call that she reported to. Officer Kroom had testified earlier that Mr. Roberto actually had followed Mr. Allen into his room and had instigated this whole situation. And in fact, Mr. Roberto is actually the primary aggressor and not the victim in this case. Based on the fact that Officer Kroom had taken out a warrant specifically for simple battery, Your Honor, not for simple assault, I'd like to ask the court to deny the warrant that the officer had sought out and dismiss this case.
Okay. Thank you. Okay. Based upon the evidence presented to the court today, I do find sufficient probable cause for a simple assault charge that will be bound over to state court. That is the order of the court today, and I want to thank the parties for their presentation of the case.
Thank you, Your Honor.
Thank you. Is the officer excused, Your Honor?
Yes.
Thank
Does
you.
it have any other cases? You don't have any other cases, correct?
I don't believe so. Officer Kroom, do you have any other cases?
No, sir.
All right.
Okay.
You're free to-
Okay, thank you.
Okay, the next case we have is that the state of Georgia versus Tyrone Garland Oliver Bailey. He's out on bond.
He is, Your Honor. And Your Honor, there was one matter related to Malaysia Morris.
Yes.
I think Officer Clevenger is on, but I think There is something I need to speak to Ms. Harvey Williams about related to Ms. Morris. Ms. Morris.
Okay. Okay, you need to do that now, or what was your preference?
At the court's pleasure, whenever the court allocates a breakout for her.
Okay, well, since we have so many hearings, let's get some more hearings and then we'll break for conference. So the next case I have on the calendar is the state of Georgia versus Kenton Tyler Beck. Is the officer present?
He is, Your Honor.
Okay, you ready to go with that one?
Yes, ma'am.
Okay, Attorney Harvey Williams, you ready to go?
Yes, Your Honor.
Okay, Deputy, if you would bring forward defendant Kenton Tyler Beck, please. Okay, Mr. Beck, this is your preliminary hearing for today. I'm officially calling the state of Georgia versus Kenton Tyler Beck, warrant number 2022 WA 19575 for the charge of simple battery. The state will be represented by Solicitor Charles Brooks, and the defendant, Mr. Kenton Beck, will be represented by Attorney Harvey Williams. Solicitor Brooks, your witness.
Thank you. Detective Flemings, if you would, activate your camera and microphone.
Yeah, can you hear me? Because I
We
can't
can.
get my video. I'm not sure why. Yeah, and I apologize to the course. I'm trying to get this video working, but there's only the audio so far.
Okay, have you been able to connect to your video? Because we'll have to have you have to have your device on for the hearing. Or your video on. Are you on a mobile device, Detective?
Yes, ma'am, I am.
Okay, can you connect to your video?
I'm trying, but for some reason it's saying it's not allowing me to connect. I'm pushing the button.
Okay, you may
Is
need
it-
to, maybe if you log out and log back in, and then when it says connect to video audio, maybe you can try that.
Yes, ma'am. Give me 1 second, ma'am. Your Honor.
Okay, great. Thank you, Detective.
Yes,
Okay,
ma'am.
Solicitor Brooks, here's his video working.
Yes, ma'am. All right. Detective Flemings, if you would, raise your right hand. Do you swear affirm testimony about giving matter now pending before the court be the truth, the whole truth, and nothing but truth, so help you God?
I do.
Thank you. Please state your name and agency for the record.
Master Patrol Officer Rob Fleming. The agency is going to be the Clayton County Police Department.
And how long have you been so employed with the Clayton County Police Department?
Approximately 8 years, 8.5 years.
And specifically, how do you serve the police department? Are you attached to a particular division, unit, or section of the police department?
My particular position would be the gang unit, but I'm attached to the Sector 1 division.
Okay. And For Sector 1, does 3749 Laramie Road, Ellenwood, Georgia fall within Sector 1?
Yes, in that part of our jurisdiction.
On December the 24th of 2022, were you employed in the same capacity?
Yes, I was.
And were you working in the same sector?
Yes, I was.
On that date, December 24th, 2022, approximately 1 in the morning, do you recall responding to that address, 3749 Laramie Road, Ellenwood, Georgia?
Yes.
Is that here in Clayton County?
Yes.
You recall the nature of the call out?
It was a domestic violence call.
And were you the first to arrive on scene?
No, I was the second one. However, it must be noted that this was a return call for service at the same location.
And did you actually do an investigation leading to charges at that scene?
Yes, I am.
During the course of your investigation, did you encounter one Kenton Beck?
Yes.
And how did you encounter Mr. Beck, and what did you learn during the course of your investigation?
During the course of the investigation, I must be let the courts know about the prior call for service in reference to the same victim and Mr. Beck in terms of domestic violence, where Mr. Beck was highly disappointed that his family didn't pick him up from Walmart, McDonald's, and therefore he had to walk from Forest Parkway all the way to the end of Ellenwood. And he was very disappointed about it because they had cars in the driveway and didn't pick him up. Mr. Beck began drinking earlier that evening, and through the midst of that drinking, it became worse and worse, and the argument intensified where law enforcement was contacted. The first call of service, we told Mr. Beck just to remain in this room and do not bother the family members for the remainder of the evening, and that we will be on our way to the next call of service. However, it must be noted to the court that Clayton County Police was called back to the location about 27 minutes after we left, in reference to Mr. Beck making physical contact with the victim of the residence at the same location. The same officers, myself and Officer Wildman, arrived back to the location. And at this point, we had made contact with Mr. Beck in the living room hallway with a jacket on. Mr. Beck stated that he got in an argument again after being told to stay away from the individual. And Mr. Beck said that he went in the room and admitted to going in the room to argue with the man and used his chest bump to the chest with the victim to gain entrance to the room. Therefore, the victim uses his arm to remove Beck out of his room. Mr. Beck stated that the reason for going into the room, as I stated a second ago, was to admit the arguing it again and also to see his child that was also in the room with the mother, who was trying to be separated from Mr. Beck because of his behavior. At that time, I found sufficient probable cause to place Mr. Beck under arrest for simple assault, family violence, and he was taken in custody.
And the charge you pursued was simple assault or simple battery?
I believe I have simple assault, family violence.
In your report, you reported simple assault. In the warrant,
Yes,
you did a warrant or warrantless arrest affidavit?
Just a warrant affidavit, then I had to get a warrant from the judge.
Okay. And in the warrantless arrest affidavit, you pursued simple battery, family violence?
Simple assault.
Okay. Now, your testimony is that that he actually made contact with with
The victim?
Can you hear me?
I can hear you now, loud and clear. Go ahead, sir.
I say you just testified that he made contact with his chest with the victim.
Yes, and push his way into the room.
Okay. And in your during the course of your investigation, did you learn from that victim that that contact was unwanted contact?
Yes.
Okay. No additional questions at this time, here.
Okay, Solicitor Books, based on my review of the WAA, it appears the defendant was charged with simple battery.
That's
Simple
my
battery.
Simple assault.
That's my understanding as well, yeah.
Okay, but the witness testified to something different.
The witness testified he pursued a warrant for, or excuse me, a warrant for a simple assault. But once we got to argument, I was going to make the appropriate argument too.
Okay, okay. Attorney Harvey Williams. Your witness.
Yes, Your Honor. I just want to ask you, Detective Flemings, you did write in your report, simple assault on family violence was your charge for Mr. Beck.
You asked me, did I charge him for simple assault in my report?
Yes.
Yes, ma'am.
And did Mr. Beck admitting to doing anything beyond, going into that room that Mr. Trice is blocking it from?
Yes, he did. He said he had rented a room and he used his body to enter the room. However, he was more disappointed that the victim used his hands to remove Mr. Beck out of the room.
Nothing further, Your Honor.
Okay, any redirect? Solicitor Brooks.
To be clear, Detective Flemings, the report itself is not a charging document, correct?
Yeah, the report is a simple assault charge on it, sir.
Okay, and the charging document, being a warrant or warrantless arrest affidavit, what did you pursue in the warrant or warrantless arrest affidavit? Do you recall? Do you have that in front of you?
No, I don't, because we don't have the warrant WAA with us. It's when we take it to the jail. It might have been a minor error on my end in terms of the charge. But on this report is simple assault, sir.
Okay, and when you actually fill out that paperwork, you actually sign that paperwork, correct?
That's correct, sir.
And you attest to the facts that underpin the charge, is that right?
Say that's for, sir.
And you attest to the charges, that the facts that will underpin the charge, is that right?
Yes, sir. Correct.
And then that's actually notarized, is that correct?
That is correct, sir.
Okay, all right, no additional questions, John.
Okay, we're ready for closing. I'm sorry, do you have any witness, Attorney Harvey Williams?
No, I don't, Your Honor.
Okay, we're ready for closing. Solicitor Brooks.
Yes, ma'am. Your Honor, the officer's testimony, detective's testimony is that Mr. Beck did make physical contact with another, unwanted contact with another with his chest. The officer reported through his testimony and through his report that he pursued simple assault. But the facts of simple assault would be that that he didn't make physical contact. The testimony that he proffered to the court was that he actually made physical contact with his chest to push his way into a room to get to the mother of his children, who didn't want contact with him at the time. Your Honor, the state believe that the officer's testimony is sufficient for the charge to be bound over as it is charged in the warrantless arrest affidavit. The court can take judicial notice of the warrantless arrest affidavit, as I believe it is in front of the court. The officer did testify that he did attest to the facts that underpin the charge, and it was notarized on the day of the incident. Additionally, the officer did testify that both the victim and Mr. Beck lived in the same household, supporting the family violence aspect of the simple battery charge. The state will reserve the remainder of his argument after counsel's argument.
Okay, Attorney Harvey Williams.
The police report charged him with simple assault, Your Honor. We're just asking that just by brushing by him, that was not battery onto Mr. Trice at that time.
Okay. Solicitor Brooks.
Your Honor, the state's position that the officer's testimony is far more than a brush by. This is not a passing glance, touch or whatnot. The officer's testimony was that Mr. Beck used his chest to push past an individual who was trying to keep him out of the room. And as such, we believe there is sufficient evidence for the case to be bound over, sufficient evidence to support probable cause for the case to be bound over to state court, and would ask the court to do so.
Okay. Let's see here. After hearing the argument, I do find a sufficient call to bound over the charge of simple assault and not simple battery. That is the order of the court today. And I want to thank both parties for their presentation of the case.
Thank you.
Thank you.
Okay, the next case we have on the calendar, State of Georgia versus Flennard Bentley Jr.
Your Honor, just, can I confirm just officer's appearance?
Yes,
Officer Sanders, Jay Sanders?
Yes, sir.
Okay, all right. State's ready.
okay, great. Okay, deputies, if you will bring forth Flennard Bentley Jr. Okay, Mr. Bentley, this is your preliminary hearing for today. I'm officially calling the State of Georgia versus Flennard Bentley Jr., warrant number 2022 WA 19602 for the charge of battery, family violence. Solicitor Charles Brooks is representing the state, and the defendant is represented by Attorney Jay Kim. Solicitor Brooks, your witness.
Thank you, Your Honor. Officer Sanders, if you would, activate your camera and microphone. Thank you, sir. Raise your right hand. Do you swear affirm testimony about to give in a matter not been before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear and affirm.
Thank you. What agency, state your name and agency for the record.
I'm Officer Sanders. I work for Clayton County Police Department.
And what division, unit, or section do you work in the police department?
Uniform.
What is your duties and responsibilities in the uniform division?
Patrol the area and answer calls.
Do you work in a particular area of the county?
Yes, Riverdale.
And what sector is that?
Sector 2.
5890 Riverdale Road. Is that an area in which you would have patrolled?
Yes, sir.
Is that an apartment complex?
Yes, sir.
On December the 24th of 2022, were you employed in the same capacity and working in the same area?
Yes, sir.
On that date, did you have the opportunity to respond to that address 5890 Riverdale Road regarding a domestic disturbance?
Yes.
Do you recall the underpinnings of why you were called out and what you did when you got there?
Yes.
Would you recount for the court what led you out there and what did you do during the course of your investigation out there?
I was dispatched there because there was a call made from a female that stated she was attacked by her older brother. When I arrived at the scene, I identified the female as Asia Abraham. She was hysterical and she told me that she was slapped in the face during an argument, which caused her tooth to fall out. She showed me her missing tooth and that she was bleeding from her mouth. She refused to allow me to take photos. She refused to write a statement, but she did point out the person in particular, Flennard Bentley, who hit her. I made contact with Flennard at the residence. He stated to me that they were having a family argument. Both parties declined to tell me what the argument was about, but he did admit to pushing her. He never admitted to actually hitting her in the face, but based off of the injuries and both verbal testimonies from both parties, I arrested Flennard Bentley for battery, family violence.
And did you confirm that they lived in the same household?
Yes, sir. Asia Abraham confirmed that they had been living together for the past 3 years. And they also, both parties also advised me that they're brother and sister.
All right. No additional questions, y'all.
Okay, take him your witness.
Yes, Your Honor, thank you. Officer Sanders, so you had stated that there was a female who had called you in regards to a domestic disturbance. Is that correct?
Yes, sir.
Do you know who that female was?
Asia Abraham.
Miss Abraham was the individual who had called you, the police. Is that correct?
That's what I was told from dispatch.
Okay. So when you arrived earlier, you had testified that you had spoken with Miss Abraham. Is that correct?
Yes, yes, sir.
And she is the alleged victim in this case, correct?
Yes, sir.
Okay. You were advised by her based on your police report that she had told you that Mr. Flennard had slapped her across the face, causing one of her teeth to become dislodged. Is that correct?
Yes, sir.
So when you spoke with Ms. Abraham, did you observe, I believe you had stated earlier, you observed bleeding and a tooth missing? Is that correct?
Yes.
Okay. Did you actually observe the missing teeth? Like, was it on the floor? You know, did you?
No, I didn't see the missing tooth because apparently, according to both parties, the situation occurred inside the residence and neither party allowed me into the residence. This occurred right at the threshold of the residence.
Okay, so the incident occurred inside. However, both parties ended up not allowing you to go back inside to do a
Yes.
further investigation. Is that correct? Okay. You stated earlier that Mr. Flennard had stated that he did push Miss Abraham away. Is that correct?
Yes.
Okay. In your police report, I believe you had mentioned that Mr. Flennard had told you that he had pushed Miss Abraham away to de-escalate a situation. Do you recall putting that in your police report?
Yes, sir.
Okay. However, you ended up arresting Mr. Flennard, even though, you know, both parties' testimony contradicted each other. Is that correct?
Yes, sir.
Okay. Miss Abraham, would you say that she was hostile and uncooperative?
I wouldn't say she was hostile, but I would say she was uncooperative.
Earlier,
She
you said,
appeared.
go ahead, sorry.
She appeared as if she didn't want her brother to go to jail, but she at the same time she did point him out to me when I asked her who was the person that hit her, because there was multiple people at the residence at the time.
Okay. So you're saying that she may have been concerned about, you know, her brother being arrested because of this. That's what you're
Yes.
saying? Okay. Could there also be another alternative, you know, scenario where maybe what she had told you guys wasn't the actual truth and, you know, she didn't want to get her brother in trouble? Could that be a possibility?
Objection, speculation.
Sustain.
Officer,
I-
don't answer that.
Officer, so let me see. Miss Abraham, you were trying to get further information from her to do your investigation, isn't that correct?
Yes, sir.
However, she ended up not cooperating and just leaving I believe in the police report, you said that Miss Abraham got into a friend's car and left the scene. Is that correct?
Yes, sir.
So you weren't even there, correct? You don't know what happened. You're just, you know, you made your arrest solely based on the testimony of two parties, correct?
I wasn't there when the incident occurred. I made my arrest based off of the testimony from both parties. It was apparent that there was a physical altercation. And even though Mr. Bentley didn't admit to slapping her across the face, he did admit to using his hands to, you know, commit battery against her, which led to her tooth falling out. He wasn't forthcoming with what the situation was at all. He didn't want me there. He didn't even want to indulge into what the argument was about.
Sure. Neither was Miss Abraham. She didn't want you over there as well, correct?
Correct.
Okay. And then also, like I stated earlier, you're claiming that, you know, Mr. Flennard had initiated all this, but on the police report, you had mentioned that he was just de-escalating the situation by pushing Miss Abraham away.
So I never stated that he caused the argument, but the end result was that she was battered.
Okay. No further questions, Your Honor.
Okay, any redirect, Solicitor Brooks?
Yes, ma'am. Officer Sanders, you testified that you observed Miss Abraham's to be bleeding from the mouth.
Yes, sir.
Did you see the place where the tooth once was?
Yes, sir.
And was that where she was bleeding from?
Yes, sir.
Okay. No additional questions.
Okay, any other witness, Solicitor Brooks?
None for the state, Your Honor.
Okay, Attorney Kim, any witnesses?
No witnesses, Your Honor, from the defense.
Okay, we're ready for closing.
State of reserve, Your Honor.
Okay, Attorney Kim?
Yes, Your Honor. Based on Officer Sanders' testimony, Your Honor, I don't believe there was a thorough investigation that was done at this time. It appears that Ms. Abraham had called the police. However, she was uncooperative when the officers did arrive to question her in regards to what happened. She was not willing to, you know, provide any additional information other than that Mr. Flennard had slapped her across the face, causing her tooth to become dislodged. Furthermore, Your Honor, as Officer Sanders had testified that he had provided in his police report that Mr. Flater had stated that he had only pushed Miss Abraham away to de-escalate the situation, potentially just acting in self-defense. Furthermore, Your Honor, due to the fact that Miss Abraham was not cooperative, not able to provide any additional information, there's not any certainty whether Mr. Flater had actually, in fact, initiated this offense or had committed the offense. So that being said, Your Honor, I'd just like to ask the court to dismiss the warrant due to lack of probable cause.
Okay, thank you. Solicitor Brooks?
Yes, ma'am. What's before the court is not whether or not Mr. Flannery initiated an argument in the context of his family, but that he did make physical contact of insulting or provoking nature with another without their consent and did leave visible evidence of injury. The state believes there's sufficient evidence for the charge of battery, family violence to be sustained. In fact, the state could argue in fact that there's sufficient evidence for aggravated battery, saying that her tooth was she can no longer use that tooth. And I believe the charge of aggravated battery says that a person commits the offense of aggravated battery when he or she maliciously causes bodily harm to another, depriving him or her of a member of his or her body. A tooth is a member of the body. Being knocked out of her mouth deprives her from use of that member. We're not asking that it be bound over aggravated battery, but there is sufficient evidence for it to be considered based on the officer's testimony. Whether or not Miss Abraham was cooperative with the officer at the scene is not of any consequence as relates to whether or not there's sufficient evidence for the charge to be bound over. And we believe there is sufficient evidence for the charge to be bound over and ask the court to bound the charge over.
Based upon the evidence presented to the court today, I do find sufficient probable cause to bound over the charge of battery, family violence to state court. That is the order of the court, and thank both parties for their presentation of the case.
Thank you, Your Honor.
Okay. The next case we have on the calendar is at position 6, Devon Lamar Berry. State ready to proceed as officer. I'll see a name for the state witnesses. Is the officer available?
State is ready, Your Honor. Officer Bowling.
Okay, and then Attorney Harvey Williams, you're ready.
Yes, Your Honor.
Okay, Deputy, if you would bring forward Devon Lamar Berry for his preliminary hearing. Okay, we're ready to proceed. I'm officially calling the state of Georgia versus Devon Lamar Berry. Sir, this is your preliminary hearing for warrant number 2022 WA 19669 for the charge of battery on a law enforcement officer. The state is represented by Solicitor Charles Brooks. The defendant, Mr. Berry, is represented by Attorney Harvey Williams. Ready to proceed, SG Brooks?
Yes, ma'am.
Okay, please proceed.
Thank you, Your Honor. Officer Berry, if you would, Bowling, if you would raise your right hand. Do you swear or affirm testimony about to give in the matter not pending before the court be the truth, the whole truth, and nothing but the truth of you got?
I do.
If you would, tell us your name and agency.
My name is Officer Bowling, and I work with Clayton County Police Department.
And how long have you been so employed with the Clayton County Police Department?
I'm sorry, sir, what did you say?
How long have you been so employed with the Clayton County Police Department?
Almost 3 years.
And what division, unit, or section do you work in the police department?
I work in a uniform division in Sector 2.
Is it part of your duties and responsibilities to respond to general call outs of 911?
Yes, it is.
On December the 26th of 2022, were you working in the same capacity?
Yes, I was.
Do you remember getting a call out to the area of 1120 Brook Way here in Clayton County?
Yes, sir, I do.
And was that call out related to a domestic violence or domestic disturbance incident?
Yes, sir, it was.
Would you recount for the court the context in which you were called out and what you did during the course of your investigation and if it led to charges?
Yes, sir. We were called out for a domestic disturbance or from a Mamie Williams. She had alleged charges against Mr. Berry, I believe of simple battery and theft by taking in criminal trespass. We attempted to interview Mr. Berry. He refused at his residence. He refused to come outside and speak with us or to allow us to go inside his home and speak with him. We asked him multiple times to open the door to do either way due to us having criminal charges or criminal allegations against him. Mr. Berry said he would not speak of us. He wanted to speak of a supervisor. We then got a supervisor. Oh, and he refused to provide his name as well for our investigation. Sergeant Thompson, the supervisor, did come out on scene. He also attempted to get Mr. Berry to either allow him to come inside the house or for Mr. Berry to come outside the house. Mr. Berry repeatedly refused to let him in. Sergeant Thompson was eventually able to make access into the house. Well, we did get Mr. Berry's name. We found that he had an active warrant out of another county. Sergeant Thompson was allowed in the house by Mr. Berry. He then placed Mr. Berry in custody at this time. And then myself and another officer were able to get Mr. Berry out of the house. He continuously pushed away from us, pulled away from us. He threw himself on the ground at one point where we had to pick him up. And then he ran into a car hood where both he and I fell onto the car hood. We continued trying to get Mr. Berry back to the patrol vehicle. I'm sorry, yes, sir.
During the course of this exchange, would you say he was actively resisting arrest?
Yes, sir. He was actively resisting.
And to be clear, he was arrested for a warrant out of another county?
Well, at this point, we were going to go with the obstruction, but he also did have a warrant out of another county.
All right. As you were trying to effectuate the arrest, you stated that he ran into the hood of a vehicle and
Yes,
it caused both of you to fall on the hood.
Yes, sir. He kind of pulled me into it because he flung himself over the hood of the vehicle.
What else happened?
Upper half of his body. And then we got him over to our patrol vehicle. He did kind of square up with me at one point and kind of got in my face. Then we tried to put him into the car. I saw that he had a cell phone in his hands. I grabbed the cell phone or tried to grab the cell phone out of his hands. He kind of pulled back on it. I got the cell phone out of his hands. He turned around. Because I'm standing right next to him. He turned around again and lunged his face into my face. I put my right hand up and put it on Mr. Berry's face to push it back. I didn't know if he was going to bite me or spit on me. And he bit my finger at that point, which caused it to cut open and bleed. And then we were able to put him into the car at that point.
After that, you were able to finish completing the arrest?
Yes, sir.
Do you recall the warrant that you referenced out of the other county? Was that warrant verified?
I do not recall the warrant. We did not turn it over due to having the obstruction charges.
Okay. And so he was being detained pending verification of the warrant?
Yes, sir.
Okay. All right. No additional questions at this time.
Okay, and I just want to, I was remiss in not including the second warrant number for Mr. Berry. It's actually warrant number 2022 WA19670 for the charge of obstruction or hindering a law enforcement officer. So I did want to put that warrant number on the record. Attorney Harvey Williams, your witness.
Officer Bowling, Did Mr. Berry actively struggle before y'all got him out of the house or while you were in the house?
It's when Sergeant Thompson went into the house is when he started actively struggling.
And you say he bit you. You sure you didn't injure your hand in the tumble on the car?
No, ma'am, it was not injured at that point. It was a bite mark on my hand or a cut on my hand from the bite.
Okay. No further questions, Your Honor.
Okay. Solicitor Brooks, any redirect? Solicitor Brooks? You're on mute.
I'm sorry, Your Honor. Officer Bowley, at the time that Mr. Berry was resisting arrest, did you actively tell him to stop resisting?
Yes, sir. We gave
And did
him
he-
verbal commands.
And did he respond to the commands?
No, sir, he did not.
Okay. All right. No additional questions.
Okay, any other witness, Solicitor Brooks?
None for the state, Your Honor.
Okay, Attorney Harvey Williams, any witnesses?
No, Your Honor.
Okay, we're ready for argument. Solicitor Brooks?
State of reserve, Your Honor.
Okay, Attorney Harvey Williams?
The initial allegations that brought the officers to the incident location, Mr. Berry appears to be charged with those offenses. And I'm just asking the court to dismiss because if the officers hadn't come to the incident location, this whole incident wouldn't have happened. So I'm asking the court to dismiss the charges against Mr. Berry.
Okay, Solicitor Brooks?
Your Honor, it's the state's position, based on the officer's testimony, that they were actively investigating domestic disturbance incident. Mr. Berry was under no obligation to cooperate with the officer during the course of the investigation. However, the officers did learn that there was a warrant out of another county that they needed to confirm, in which they were trying to detain him, at which point he actively resisted the detention. So much in fact that these charges were born from him resisting. We believe that officer testimony is sufficient for it to be bound over for obstruction and battery against Officer Bowling, in that the officer's testimony is that Mr. Berry did bite him on the ring finger as they were trying to detain him to confirm the warrant. But for his active resistance and him biting the officer, there would be no charges. But we believe there is sufficient evidence based on the officer's testimony that would allow the court to bound the case over to state court to be resolved in state court.
Based upon the evidence presented to the court today, I do find sufficient probable cause to bind over the charge of battery on a law enforcement officer, as well as the obstruction charge against Mr. Berry. It'll be bound over to state court. That is the order of the court. I want to thank both parties for their presentation of the case. And then we will move forward with the next hearing that's on the calendar for today. Thank you.
Thank you, Your Honor.
Next case I have on the calendar is at position 8, the state of Georgia versus Mary Carter. State ready?
Ms. Baker?
I'm sorry, is the state ready? Is that your case?
Mr. Brooks, I believe you have that file.
Carter.
That's the one we were reviewing in my office, and I think you took it with you.
Thank you.
No problem.
All right. State is ready, Your Honor. State is ready.
Okay. Attorney Kim, you ready?
Yes, Your Honor, I'm ready to proceed
Okay.
forward.
Deputy, if you would bring forward defendant Mary Carter for her preliminary hearing. Okay, thank you, Deputy. I'm officially calling the state of Georgia versus Mary Carter, warrant number 2022 WA19773 for disorderly conduct. The state of Georgia is represented by Solicitor Charles Brooks, and the defendant, Ms. Carter, will be represented by Attorney J. Kim. Solicitor Brooks, your case.
Thank you, Your Honor. Officer Jamel, if you would, activate your microphone. We can't hear you. Officer Jermel, can you activate your microphone?
Okay, can you hear me?
We can't hear you.
Okay.
All right.
Okay, so can you turn on your device, please?
Yes, Your Honor, it's turned on.
He has, looks like he's using two devices, Your Honor.
Okay, okay.
One for audio and one for video, looks like, yeah.
Yes, Your Honor. With your permission, I'm using my phone for audio and the desktop for video.
Okay, for the record, you identified on the Zoom as, is that PGERMEIL? That's your screen name?
That's correct, Your Honor. That's
your video, and then you have the, I guess for the audio, you have the OnePlus Nord N105G. Is that correct?
Yes, Your Honor.
Okay, thank you.
All right, if you would raise your right hand. Do you swear affirm testimony about giving the matter not opinion before the court be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, tell us your name and agency.
Officer Pierre Germain, Atlanta Police Department.
And what section or area of the police department do you work?
I work on the CSD, Customer Service Division, and I'm assigned at the airport.
You're assigned at the airport?
That's correct.
Specifically the atrium area at 6234 Spine Road. That's located here in Clayton County?
That's correct.
On December 28th, 2022, were you employed and working in the same area?
Yes, sir.
Was there an incident in which you became familiar with a woman named Mary Carter?
Yes, sir.
How did that incident come about, and recount for the court the facts underpinning the incident?
First, I was patrolling the third floor of the atrium where we mostly have offices. Miss Carter was sitting in front of one of the offices with all her belongings on the luggage cart, blocking the door. I approached her and asked her to please move away from the entrance door. And she told me she was there to see somebody at the USO. So she proceeded and went to USO. And about 3 or 5 minutes later, the USO called, request to remove Miss Carter from the USO because she didn't have any business there. And that's when the whole incident happened there.
Now at the USO area, did the folks who called, did they have reason to believe that their property or person was going to be harmed or injured?
Well, according to the USO personnel, she was kind of belligerent toward them, not physically, but yelling and belligerent toward them. Yes.
Belligerent.
Yes.
Okay.
So I have an accent. So
no worries. No worries. I understand. And did you ever make contact with Miss Carter?
Yeah, I did. The second time I went to the USO, and then we trying to remove her from the USO. And that's when she started running around the whole atrium, making a loud noise and police attacking her and stuff. It took at least 3 officers to help me to corner her somewhere, so we can remove her from the third floor of the atrium.
And the third floor of the atrium, is that an area that passengers or the general public are generally allowed?
No, that would be the second floor. That's what passengers are allowed. The third floor is mostly military personnel. That's what the USO is for. Okay. Mostly military personnel and the offices for the airport, administration of the airport. Yes.
Did she identify herself as a member of the military?
To USO she did, but she was not.
And did she ultimately provide you with the name of the person she was trying to reach in the USO?
No.
In fact, I think your testimony said it was the folks, personnel at the USO that asked her to be removed?
That's correct.
Okay. Why didn't you just charge her with or give her a criminal trespass warning?
Well, she had a previous encounter at the airport, but she didn't have a warning at the time. Nobody warned her, either on writing or verbal, not to be on that side of the airport because she could be traveling or coming from a flight. But she did have a encounter with police in the Delta headquarters. Apparently, she used to be a Delta employee, and there was a previous incident where she attacked an officer at the Delta headquarters. But on that side of the airport, she didn't have any warning not to be there.
Had she, and in this incident, did you actually give her a criminal trespass warning?
That's correct. Yes, sir.
All right. No additional questions at this time.
Okay, Attorney Kim, your witness.
Yes, Your Honor, thank you. Officer Pierre, so you had testified earlier that Ms. Carter had not ever received a criminal trespass warning. Is that correct?
Not to my knowledge, no.
Okay, so due to there not being a criminal trespass warning, there was nothing restricting her from appearing on, to that location, correct?
No.
Okay. Furthermore, you arrested Ms. Carter, I believe, under the basis of disorderly conduct. Is that correct?
Yes, it should be disorderly conduct and criminal trespass. I don't know if I make a mistake in the paperwork.
Well, did you ever take a warrant out for a criminal trespass?
I can't recall. I don't have the warrant document with me. I can't recall.
Okay. Earlier, you testified you had given her a warning, correct?
That's correct.
Okay. You need a warning in order to find someone criminal trespass. Is that correct?
That's correct. Well, the USO wanted her to be removed. That's when she resisted being removed.
You wrote a police report in regards to this incident. Isn't that correct?
Yes, sir, I did.
Okay. Your police report should be a complete and accurate report of what happened. Isn't that correct?
Fairly, yes. That's a fair statement. Yes.
Okay. In your police report, you had stated Ms. Carter started running and making loud noise inside the atrium, being disorderly. Is that correct?
That's correct.
Okay. What did she do? What noises was she making where you decided to end up arresting her for disorderly conduct?
Mostly making a scene. Why you attacking me? Why you assaulted me? Accusing me of assaulting her when I never made contact with her yet, physically contact with her yet. Why you assaulting me? What? Please help, stuff like that. Yes.
Okay. So you ended up just arresting her because she was being loud. Is that correct?
Being disorderly. Yes.
Being disorderly. Well, you defined disorderly her yelling, correct?
According to the report, yes.
Okay. Did she at any point make any, act in a violent or tumultuous manner toward another person?
Well, I don't think she meant to hurt any of us, but however, she was resisting us approaching her, resisting us, removing her from the floor. That's correct. Physically resisting, yes.
Okay, but you weren't in reasonable fear of your safety, correct? She was just, being loud, correct?
At the time, no. But later on, I found out that she had a knife on her person. So at the time, I didn't have any fear of course.
You only found out about the knife after you had arrested her for disorderly conduct. Is that correct?
That's correct.
Okay. Do you believe she was acting in a violent, tumultuous manner toward another person, whereby a property may be endangered or damaged?
I do, yes.
You do?
Yes, sir.
Could you explain in regards to that?
The way she was belligerent toward the USO personnel.
But being belligerent, people can be belligerent without putting somebody in reasonable fear of their safety. Wouldn't you agree with that?
No, sir.
Okay. Were there anybody else nearby that could hear her language, 14-year-olds or anything like that, minors?
It's a big scene. Had plenty of people in line to go to US TSA at the time. Was full of passengers, full of airport employee. Yes, sir.
Okay. Did any of them complain to you other than the USO?
Well, they're observing.
No one made any complaints, though, correct?
Beside the USO, no. Yeah, but a lot of people observing, a lot of people recording. Yes.
Okay. So you ended up arresting Ms. Carter because the USO wanted her to leave. She had never been given a criminal trespass warning at that time, though, correct?
Nothing I know of.
Okay. So you ended up arresting her because she was running around being loud, correct?
No, No, being loud.
Ask the answer, Your Honor.
Okay, sustain.
Okay, Your Honor, nothing further from defense.
Okay, Solicitor Brooks, any redirect?
Yes, ma'am. Officer Jermel, the words and language that Miss Carter used, I think you described it, she was being belligerent with the USO. Is that
Toward the-
correct?
Yes, sir. Toward the USO. Yes, sir.
Would you, during the course of your investigation, did you learn that that language was what might be considered abusive or appropriate language?
I would say so. Yes, sir.
Was it the type of language that would cause an immediate breach of the peace?
Yes, sir.
No further questions.
Okay, do you have any other witness, Solicitor Brooks?
No, ma'am.
Okay, Attorney Kim, any witnesses?
No witnesses, Your Honor.
Okay, we're ready for argument. Solicitor Brooks.
State of reserve, Your Honor.
Okay, Attorney Kim.
Yes, Your Honor, thank you. Based on Officer Pierre's testimony, Your Honor, he was not able to articulate as to the reason why he ended up arresting Ms. Carter. At no point did he articulate, what she had said. All he stated was that, she was acting belligerent. Belligerent doesn't necessarily mean, that she was acting in a manner where she would place somebody in fear of their property or their health. Furthermore, Your Honor, I believe subsequently also that Officer Pierre had testified that he had located a weapon on her, but that had only occurred after the fact, after the arrest for disorderly conduct. Given the fact that the state has not met their burden in proving the elements of this crime, I'd like to ask the court to deny the warrant.
Okay, thank you. Solicitor Brooks.
Your Honor, based on the officer's testimony, the officer did testify that Ms. Carter was in an area that's not generally used by the general public of the airport, the USO area reserved for military members of the military. Generally, the personnel at the USO asked that Miss Carter be removed. She refused to leave the area, causing the law enforcement interaction. Prior to the law enforcement getting there, the officer did testify that they advised that she was being belligerent with them in such a manner, using such words that could be considered appropriate or abusive, which would cause an immediate breach of the peace. We believe that there's sufficient evidence under 161139 subsection A3 of the disorderly conduct statute for the case to be bound over as such, and ask the court to bind it over to be resolved in state court.
Okay. Based upon the evidence presented to the court today, I do find sufficient probable cause to bind over the charge of disorderly conduct to state court. That is the order of the court today, and I want to thank both parties for their presentation of the case. That will conclude your preliminary hearing for today, Ms. Carter. Thank you.
Thank you, Your Honor.
May I be excused, Your Honor?
Yes.
Thank you.
And if you will log off both of your devices, you don't have any other cases, officer, do you?
No, ma'am, I don't.
Okay, if you will log off both devices, I would appreciate it. Thank you.
Thank you, ma'am.
Position 9, we have the state of Georgia versus Larry Terrell Crook. Ms. Baker.
Yes, Your Honor, the state is
Great.
ready.
Okay, great.
Officer-
And then I understand from that the defendant will be represented pro se. Let me just see if he would like to have a counsel. Attorney, I'm sorry, Mr. Larry Terrell Crook. Mr. Crook, can you hear me? Okay, Deborah, you can turn. Sir, are you currently represented by counsel?
Attorney, I haven't seen anyone yet.
Okay, would you like for me to appoint an attorney to represent you, sir?
Yes.
Okay, let me just see here. Let me look at your court appointed form quickly. Okay, it doesn't appear that you completed one, sir. I'll have to complete one for you. Do you currently have a job?
Yes, ma'am.
Okay, where are you employed?
I work at McDonald's.
Okay. And what are your monthly wages?
I get disability too because I'm disabled. About 2,000.
Okay. So based on that, you will qualify for a court-appointed attorney. So we'll have to have an attorney appointed to represent you. Attorney Baker, you're opposed to a continuance to allow me to appoint Mr. Cook a court-appointed attorney?
No, Your Honor, I am not.
Okay. So I do have a misdemeanor preliminary calendar on either, probably we could look at the 31st of January, I'm sorry.
Yes, Your Honor.
Would that work? Would the officer be available on January the 31st?
I will have our office contact if he's present on the Zoom.
Okay. So we'll, Ms. Wilkerson, Tina, we'll continue that until January 31st. That'll be my calendar. Did you get that, Mr. Wilkerson, Tina?
Yes.
Okay. You. So, Mr. Crook, we're going to continue your case until your preliminary hearing to January 31st, 2023 to allow us to get an attorney appointed to represent you.
Okay, Your Honor, is there any way I can get a bond reduction so I can continue this?
Not at this time. We'll have to do your preliminary. Okay. Thank you, sir. Thank you. The next case we have on the calendar is at position 12, the state of Georgia versus Lamel Tremont Edwards. Is the state ready, Ms. Baker?
Yes, Your Honor.
Okay. Attorney Harvey Williams.
Yes, Your Honor.
You're ready, correct?
Yes.
Okay. Deputy, you bring for Mr. Edwards for me?
We're bringing them forward right now, Your Honor.
Okay, thank you.
You're welcome.
Hey, Mr. Edwards, please pay attention. We're officially calling, this is your preliminary hearing. I'm officially calling the state of Georgia versus Lamel Tremont Edwards for warrant number 2022 WA19676 for the charge of criminal trespass. The state will be represented by Ms. Rakia Baker, and the defendant will be represented by attorney Harvey Williams. Ms. Baker, your witness.
Yes, Your Honor. Officer Nimmons, could you state and spell your name for the record?
My name is Sherinique Nimmons. The spelling of my first name is CHERONIQUE. Last name is going to be NIMMONS.
Thank you. And what is your current employment?
I work for the Clayton County Police Department as a police officer.
I'm sorry, let me swear you in. Could you hold up your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And just so we can go back, what is your current employment?
I'm employed by the Clayton County Police Department as a police officer.
And how long have you been employed with Clayton County Police Department?
About 2 years.
Okay. And what is your current assignment?
Uniform Patrol, Sector 4, Day Watch.
And what does your duties entail?
Mediation, arrests, different things like that.
Okay. Do you recall December 26th of 2022, what your assignment was?
Yes, ma'am. It was Uniform Patrol, Sector 4, Day Watch.
Okay. And were you called out to a Dunkin' Donuts?
Yes, ma'am.
And was this Dunkin' Donuts located at 6622 Tier Boulevard in Clayton County,
Yes.
Georgia?
Yes, it was.
And do you recall what this dispatch was in reference to?
It was in reference to a disturbance. There was a male inside of the Dunkin' Donuts that should not be there and was refusing to leave.
And were you able to identify that male by name?
Yes, ma'am. Lamel Edwards.
Okay. And did you speak with anyone that worked for the Dunkin' Donuts when you first?
Yes,
appeared
ma'am.
on
I spoke with one of the owners and she stated that he wasn't supposed to be there and he was refusing to leave.
Okay. Did she inform you of a previous warning that was given to Mr. Edwards?
Yes, I believe on December 21st, he was given an official criminal trespass warning and told that he wasn't allowed to be on the property.
And when you appeared at the property, was the defendant present?
Yes, he was. He was sitting in a booth, eating a sandwich, attempting to charge his phone.
Okay. And so just so I'm correct, the Dunkin' Donut owner informed you of a warning on December 21st of 2022?
Yes, ma'am.
And did they state that that warning was for Mr. Edwards?
Yes, it was.
Okay. No further questions for this witness.
Okay, Attorney Harvey Williams.
Officer Nimmons, did the Dunkin' Donuts employees admit to selling Mr. Edwards the sandwich that he was eating?
No, they sold a lady the sandwich.
Did they admit to asking Mr. Edwards to leave, and did he acknowledge them when they told him to leave?
Yes, they asked him to leave. They told him, they reminded him that he wasn't supposed to be there and he refused to leave.
So did he verbally, admit to saying that he heard them tell him to leave?
Yes, he kept saying he doesn't understand why they don't want him there, why they don't want him there.
No further questions, Your Honor.
Okay, any redirect Attorney Baker?
No, Your Honor.
Okay. Do you have any other witnesses?
No, not from the state, Your Honor.
Okay, Ms. Harvey Williams, do you have any witnesses?
No, I don't, Your Honor.
Okay, we're ready for argument.
The state reserves.
Okay, Attorney Harvey Williams.
I was gonna say, we're just asking that the charge against Mr. Edwards, because he was actually in the property consuming food, and so therefore we'd ask the charges against him be dismissed, Your Honor.
Okay, and A.S. Baker.
Yes, Your Honor. The state asks that the case be bounded over under OCGA 16-721. A person commits the offense of criminal trespass when he or she remains upon the land or premises of another when an authorized representative of the owner has asked them to depart. Here, officer testified that the owner of Dunkin' Donut informed her of a previous warning on December 21st of 2022 to Mr. Edwards, informing him that he was to leave the property and not come back. And at that time, on December 26th of 2022, Officer Nimmons witnessed the defendant sitting in the Dunkin' Donut after the owner informed him that she told him to leave. So at this time, the state feels like that we have enough probable cause to move forward on the criminal trespass.
Okay. Based upon the evidence presented to the court today, I do find sufficient probable cause to bound over the charge of criminal trespass against Mr. Edwards. That will be the order of the court today, and I want to thank both parties for their presentation of the case. Mr. Edwards, that will conclude your preliminary hearing for this morning. And then Officer Nimmons, if you don't have any other cases on the calendar for today, you're released.
Thank you, ma'am.
Thank you. Okay, moving on to position 9, the state of Georgia versus Kevin L. Flowers. Is ASG Baker, you ready?
Sorry, Your Honor, I have people all in here speaking with me. Could you repeat that? Which
For state of Georgia versus Kevin Flowers, is the state ready?
Yes, Your Honor, we are ready.
Okay. Okay, Deputy, if you would, and then Attorney Kim, you ready?
Yes, Your Honor.
Okay, Deputy, if you would bring forward Mr. Kevin L. Flowers. Okay, we're ready to proceed. Mr. Flowers, this is your preliminary hearing. I'm officially calling the state of Georgia versus Kevin L. Flowers, warrant number 2022 WA 19775 for the charge of obstruction of a law enforcement officer, as well as warrant number 2022 WA 19776 for the charge of simple battery. And the third charge, warrant number 2022 WA 19777 for the charge of disorderly conduct. The state will be represented by ASG Rakino Baker, and the defendant, Mr. Flowers, will be represented by Attorney J. Kim. Attorney Baker, your case.
Yes, Your Honor. Officer Mendez, could you cut your camera? Oh, your camera and mic is on. Could you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth during this testimony?
Sure.
Okay, thank you. Could you state and spell your name for the record?
My name is Officer Melendez, Jonathan.
Okay, and you can put your right hand down now. Where are you currently employed?
I'm sorry?
Where are you currently employed?
I am employed as a model police officer.
Okay, and what does your duties entail?
I am usually do customer service, surveillance.
Were you employed with MARTA Police on December 28th of 2022?
Yes.
And do you recall what was your current assignment at the time?
My current assignment?
Yes.
Yes, I was just at the airport. I was getting ready to close the stations. And that was it for that.
Okay, thank you. When you say stations, are you referring to MARTA station?
Yes.
MARTA station. Okay, and do you remember whether that MARTA station was located in Clayton County?
Yes, it was on the airport, yes.
Okay, and did you come in contact with anyone around 1 or 2 p.m.?
Approximately about 1:30 a.m.
And do you recall who you came in contact with?
That will be Mr. Kevin Flowers.
Okay, and could you explain to the court how you came in contact with Mr. Flowers?
Well, as I stated, the stations were getting ready to close. So around 1:30 a.m., the one of the last trains that was there to that was going to be out of service, Mr. Kevin Flowers was sleeping when I noticed him. I went towards Kevin Flowers. I woke him up. I also stated that the station was closed, that the trains were out of service. I remember Mr. Kevin Flowers waking up pretty angry.
Okay. Do you recall what he stated to you when he woke up?
As he woke up, he said he would knock my goddamn head off. Okay. He started swinging some punches.
Okay.
As he started swinging some punches, I was walking backwards just to make sure he didn't hit me or didn't make any contact with me.
Yeah, sure. So would you say that that act was violent in your opinion? Okay.
Once he stopped, he returned back to the train, and then I also returned to the train just to let him know, sir, the station is closed, trains are out of service. But he started swinging back punches at me again. That's when I used my OC spray and sprayed it on his face.
Okay, and did you make an arrest for Mr. Flowers?
Yes, I did.
And during this attempt to make an arrest, did he resist at any time?
Yes, he did. Once I grabbed his right arm, I was letting him know he's under arrest. I used force. And he said to let him go. And while he was being handcuffed by two other officers, one sergeant and one canine officer, he was still resisting arrest as he was being handcuffed.
Okay, and as a result of him resisting this arrest, did you have any injuries?
No, I did
Okay.
not.
All right, no further questions for the witness, Your Honor.
Okay, Attorney Kim.
Yes, Your Honor, thank you. Officer, so when you encountered Mr. Flowers, you had stated that he was asleep, correct?
That he was asleep? Yes.
Okay. So did you approach him and touch him? What happened?
I approached him,
Okay.
and to wake him up, I did touch him. Yes.
Okay. At any point, did you announce that you were an officer?
No, that's why I actually gave him a break. That's why I did not try to arrest him at the first time that he swung at me. I was like, he maybe did not know who I was, so I gave him a break. But then once he returned to the train, and I returned inside the train too, he started swinging back at me again. That's when I used my OC spray.
Okay. At what point did you tell him that he was under arrest?
Once I grabbed his right arm.
Okay, so you didn't tell him before you had made contact with him, correct?
No, I did not.
So he would not have been aware that he was under arrest at that time, correct?
That is correct.
Additionally, you did write a police report in regards to this incident. Is that correct?
Yes, I did.
Would you say that police report is a complete and accurate report of what occurred on that date of the incident?
I would say so, yes.
In the police report, I believe you had stated that Mr. Flowers was charged with simple battery on a police officer, obstructing the law enforcement, and disorderly conduct. Is that correct?
I did notice I did write simple battery, but if you do check on the dash numbers, it's 16-5-20. That is simple assault. I must have accidentally wrote simple battery instead of simple assault.
Was Mr. Flowers, so you had stated that you had pepper sprayed him, is that correct?
That is correct. I used my OC spray, yes.
So did you pepper spray him before you ended up putting him in handcuffs?
Yes, I did.
Okay. This was before you even told him that he was under arrest, correct?
That is correct.
Okay. Do you believe he may have been, do you believe that he was, okay, sorry, give me a second. Let me rephrase that. Is there a possibility that the way he was acting was due to him being pepper sprayed, not due to him resisting arrest?
I do not believe so.
Okay. No further questions, Your Honor.
Okay, ASG Baker, any
Just
redirect?
Just a few questions, Your Honor. When you typically work at the Martyr Police Train Station, what type of uniform do you have on?
Usually I have a green shirt and my vest and blue pants.
And does your vest indicate, I guess, police or security anywhere on your vest?
Yes, I do have my badge here.
So it's safe to say that even if you did not make the announcement, once Mr. Flowers was awakened, he could identify you as police by your uniform.
I believe he had enough time to recognize, yes.
Okay, and could you explain to the court why you pepper sprayed the defendant prior to arresting him?
He swinged a few punches at me again, even after the first rounds of the swing punches he threw at me.
Okay, and you stated that the defendant returned to the train, and that's after you gave him a lawful command to leave the train?
I did not exactly said get off the train. I was just letting him know the trains was out of service and that the station was closed. He went back at me again and started swinging punches at me.
But after you told the defendant that the train station was closed, he went back onto the train?
That is correct.
Okay, no further questions for the witness, Your Honor.
Okay, do you have, does the state have any other witnesses?
No, Your Honor, not at this time.
Okay, Attorney Kim, do you have any witnesses?
No further witnesses, Your Honor.
Okay, we're ready for argument.
Yes, Your Honor, reserved for.
Okay. Attorney Kim.
Yes, Your Honor. Based on officer's testimony, Your Honor, it appears that the officer had encountered Mr. Flowers at the airport at a train that was about to be scheduled for a maintenance. At no point did the officer testified that Mr. Flowers was sleeping. At no point did the officer at no point did the officer announce that he was an officer, was doing any investigation. Given that Mr. Flowers was just woken up, was not coherent, wasn't aware of what was happening. Based on the officer's testimony, the officer never stated that he had told Mr. Flowers to not return back to the train. Furthermore, Your Honor, let's see. At no point did the officer mention to Mr. Flowers that he was under arrest. The officer had testified saying that he only had mentioned that once Mr. Flowers was placed under arrest in handcuffs. Furthermore, based on the police report, it appears that the officer had stated that Mr. Flowers was going to be charged for simple battery on a police officer. However, based on the officer's testimony, there was no physical contact. Based on the fact that there was no reason for the officer to approach my client without making any announcements, nor the fact that he was, placed under arrest at the time, I don't believe Mr. Flowers was committing any violations of obstructing or simple battery on a police officer. That being said, I'd like to ask the court to dismiss those warrants.
Okay. ASG Baker.
Yes, Your Honor. It is the state's opinion that we have proven each element with probable cause. Defense counsel is stating that the defendant was unaware, maybe because he was waking up. But however, the officer testified that his clothing provided the defendant would notice that he was an officer. Actually, he's in the uniform now, which looks similar to a police officer. In addition, he stated that after he informed him that the train station was closing, which means
He's supposed to OD on meth that morning, and they gave him Narcan in the hospital.
Okay. What? 1 minute.
Instead of staying, he decided.
Okay.
sorry, that threw me off. The officer stated that he did inform the defendant that the train station was leaving, and instead he went back to the train, I guess to lay down again. So it is that our opinion that we have proven that he was an obstruction because the officer was trying to carry out his lawful duties of clearing out the train station. And at that time, the defendant went back to the train to fall asleep. In addition, the officer testified that the defendant in 2 different occasions basically swung on him, which would be an act of violence or placing him in reasonable apprehension. And so with those facts and the officer's testimony, we feel like we have enough probable cause to move forward on all 3 charges: simple assault, obstruction of an officer, and disorderly conduct. Thank you, Your Honor.
Based upon the evidence presented to the court today, I do find sufficient probable cause to bind over all 3 charges against Mr. Flowers, specifically for the charge of obstruction of a law enforcement officer, simple assault, as well as disorderly conduct. That is the order of the court, and that will conclude your hearing for this morning, Mr. Flowers. Thank you.
May our officer be excused? Thank you, Your Honor.
Yes, yes. Mr.
Thank you.
Yes. Okay, the next case we have on the calendar is the state of Georgia versus Jonathan Deshaun Hallowell. Is the is the state ready?
Yes, Your Honor, we are.
Okay,
Officer
and then,
Dudley, could you put your camera on and unmute? Thank you.
and then Attorney Harvey Williams, you're ready, correct?
Yes, Your Honor.
Okay, deputies, you will bring forth Mr. Jonathan Deshaun Hallowell. Okay, sir, this is your preliminary hearing. I'm officially calling the state of Georgia versus Jonathan Deshaun Hallowell for warrant number 2022WA19835 for the charge of criminal trespass. The second charge will be warrant number 2022WA19836 for the obstruction of officer. Third charge, warrant number 2022-WA19837 for the charge of use or possession of drug-related items. Those are the charges pending against you, sir. The state of Georgia will be represented by ASG Rakina Baker, and the defendant is represented by attorney Harvey Williams. State your case.
Thank you, Your Honor. Could you raise your right hand, Officer Dudley? Do you swear to tell the truth, the whole truth, and nothing but the truth in this matter?
I do.
Thank you. Could you, you can put your right hand down. Could you state and spell your first and last name for the record?
I'm Officer Brian Dudley. That's Brian, last name Dudley, Dudley.
Okay. And where are you currently employed?
Morrow Police Department.
And how long have you been employed with Morrow Police Department?
Approximately 4 months.
Okay. And what is your current assignment?
Current assignment here is uniform patrol for the Morrow Police Department.
Okay. And could you tell the court some of the duties you have as in that position?
Yes, ma'am. It's going to be traffic enforcement, 911 calls for service, disturbances, anything like that.
Okay. On December 29th, 2022, did you receive a dispatch in reference to a disturbance?
Yes, ma'am, at approximately 1,700 hours.
1,700 hours. Do you recall the location?
Yes, ma'am. It was Walmart, and that address is 6065 Jonesboro Road.
And that is in Clayton County, correct?
Yes, ma'am.
And when you arrived at the Walmart, did you speak to anyone?
I spoke with an Walmart employee by the name of Kevin Copeland. And that's Kevin spelled common, last name Copeland, Copeland.
Okay. And what did Mr. Copeland inform you of why he was calling?
Mr. Copeland stated that there was a black male who we later identified as Mr. Holloway, who was acting strange in the store, and due to his behavior, they were asking him to leave because his behavior was showing signs of unpredictableness.
Okay. And did you make contact with this suspect?
Yes, myself and three other officers, correction.
And how did you make contact with the suspect?
Mr. Copeland kind of pointed us in the right direction, and he was outside of Walmart on the, I guess you would say, east side of Walmart on the parking lot.
Okay. And at that time, how did the defendant appear?
Lack of better words, definitely under the influence of some sort of substance. His hands were clenched very tight, or one of his hands were clenched very tight. He had a very increased alertness or wakefulness. He was walking around, but no particular direction. It just really didn't make sense what he was trying to do. While we were trying to speak to him, it really wasn't really making sense as to what, when we were asking questions, he would reply back with answers that had nothing to do with our questioning. So his psychosis was just all over the place.
Okay. And you stated that you did speak with him, and when he answered, it was indirectly to your questions. Would you consider that hindering your investigation?
Yes, and most likely due to the substance intoxication.
Okay. And did you arrest the defendant in this case?
Yes. We were trying to willfully have him come to us so that we can have him escorted from the property, while trying to ask him to come speak with us. Of course, he did not come. At that time, Officer Birdlong walked up to him, grabbed him very quickly. I then approached him, placed him in handcuffs behind his back. At that time, he still had his fist clenched very tight. Hands were very sweaty. We patted him down at that time, and that's when we found a bulbous glass smoking device.
And when you say a glass smoking device, would that be considered something that you smoke drugs out of?
Yes, this particular one is a glass one with a bulbous tip that is commonly used to smoke methamphetamine.
Okay, no further questions for the witness, Your Honor.
Okay, Attorney Harvey Williams, your witness.
Yes, Officer Dudley, you said he was in a psychosis. Do you know if he understood that you were giving him a command to comply?
It's unclear. He was calling us some derogatory names. So he was alert that we were present. But, due to his psychosis, we're not sure.
So you couldn't say for sure that he was trying to not resist your commands?
Oh, he was definitely resisting. When we grabbed his hands, he became very rigid and would not put his hands behind his back.
But you previously stated that his hands were clenched in a fist when you approached him. Did you not?
His hands, but his arms were just flailing around initially. When we grabbed him to put his hands behind his back, that's when he tensed up, I guess you should say, his arms or forearms and biceps, triceps.
Okay, you said the glass smoking device is not commonly used for drugs. Is there any other application for that device?
When it has a white burnt residue inside of it, no.
And so was Mr. Hollowell, you did state that he was outside of the Walmart, not inside of the Walmart at that time?
He was outside of Walmart, but still on Walmart property.
Okay. No further questions, Your Honor.
Okay, ASG Baker, any redirect?
No, Your Honor.
Does the state have any other witnesses?
No, Your Honor.
Okay, thank you. Attorney Harvey Williams, does the defendant have any witnesses?
No, Your Honor.
Okay, we're ready for argument. ASG Baker.
Reserve.
Okay, Attorney Harvey Williams.
I would ask the court to dismiss the warrants against Mr. Hollowell because he was outside of the property. He could have been possibly walking away when the officers came up, and that they initially said he was under psychosis, so maybe he didn't understand the officers' commands to comply, and so he wasn't really actively trying to obstruct the officers. And the glass smoking device could have had other utility. He could have been using that for another application, not just drugs, Your Honor.
Okay, ASG Baker.
Your Honor, the state asks that you bound all three warrants over to state court. The officer testified that the glass bowl had white burnt residue, which would signify that drugs were used in this object. So we do believe we have proof possession of a drug-related object, being that it was found on a defendant's person when he was taken into custody. Secondly, the criminal trespass, although the defendant was found in the parking lot, we do have testimony from the officer that an employee with Walmart stated and identified the defendant as the person who was remaining on the premises. At that time, they called officers because they were unaware of his next moves. And thirdly, obstruction of an officer. Officer testified that the defendant clenched his hands up as he was being arrested. In addition, he gave misleading information to officers when they questioned him about the investigation. Those are the facts of the case, Your Honor. And now the state asks that the case be bound over the state court.
Okay, so noted. Based upon the evidence presented to the court today, I do find sufficient probable cause to bind over all three charges against Mr. Hollowell, specifically for the charge of criminal trespass, the charge of obstruction of an officer, as well as use or possession of drug-related objects. That will conclude your preliminary hearing for today, Mr. Hollowell. I want to thank both parties for their presentation of the case. Thank you.
Thank you, Your Honor.
And then Officer Dudley, do you have any other cases on the calendar for today?
No, ma'am.
Okay, you're released to go. Thank you.
Thank you, Your Honor. You have a good day. Bye-bye.
Thank you. Position 19 we have on the calendar is the state of Georgia versus Michelle Colette Johnson.
Yes, Your Honor, the state is ready.
And then Attorney Kim, you're ready to go?
Sure.
Okay. Deputies, you bring forward Michelle Colette Johnson. Thank you.
Um,
Okay, deputies, can you adjust the camera? Thank you. Okay, Ms. Johnson, this is your preliminary hearing for the pending charges against you. I'm officially calling your case, the state of Georgia versus Michelle Colette Johnson, for warrant number 2022 WA19760 for the charge of battery family violence. There's a second charge as well. Warrant number 2022 WA19761 for the charge of cruelty to children in the third degree. The state of Georgia is represented by ASG Rakina Baker, and Ms. Johnson, you're represented by attorney J. Kim. ASG Baker, your case.
yes, Your Honor. Officer Arnold, could you cut your camera on and your mic off for me? Give me 1 second. I'm sending her a personal chat.
Okay, no problem.
Officer Arnold, can you hear me? Officer Arnold, can you hear me?
I'm reaching out to her as we speak.
Okay, thank you. She's on, Your Honor. If you could just give it.
No problem.
Okay, thank you.
I understand we're all multitasking here.
Yes. Thank you. Please. Okay. Hey, could you raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth during your testimony?
I do.
Okay, thank you. You put your right hand down. Could you say and spell your name for the record?
Officer Patrick Arnold,
Okay. And where are you currently employed?
Clayton County Police Department.
And how long have you been employed with Clayton County Police Department?
Yeah, some change.
Okay, and what is your current assignment?
I'm Uniform Patrol Officer at Sector 4.
And what does your duties include?
Answering call for services, traffic. Stuff
And when you, okay, I'm sorry. Do you recall your assignment on December 28th, 2022?
Yes, ma'am.
And were you dispatched in reference to a property check?
Second time, yes, ma'am.
The second time. And was this, yes, I know it's two different incidents. And was this property check, was the property located in Clayton County, Georgia?
Yes, ma'am.
Okay. And on your second dispatch on 12/28/2022, did you speak with anyone?
Yes, ma'am.
And do you recall who you spoke with?
I remember them by last names. I know it was Anderson.
Okay.
Subject, which was the daughter, I think, the victim, and then Johnson, which would be the mom, the suspect or offender.
Okay, and when you spoke to Miss Anderson, what did she inform you?
That she pretty much that her mom attacked her. She came up in the room. She was asleep, came in the room pretty much in one of her haze or tizzies, because apparently she explained that the mom, I guess, had like some kind of mental issue going on. And she came in the room, attacked her, punched her like, I want to say about 4 times in the face.
Okay.
The kids were trying to like, help get the mom off her. Her boyfriend who was there, try to help out. Yeah, that's for the most part.
And when you stated that the children, do you recall whether these children were minors?
They were minor children, yes.
And she stated that they attempted to break up the fight between Johnson and Anderson, correct?
Affirmative.
And so that would mean they were present when the victim and the defendant were arguing.
Yes, ma'am.
Okay. And she also stated, did she inform you how the argument came about between her mother or?
I can't recall 100% at the time, at the moment. Yeah, I can't quite recall.
Okay. Do you recall seeing any injuries on the Miss Anderson on the victim?
Yes, ma'am. She had blackened eye, busted nose, and like scratches on her.
Okay, so this was visible, correct?
Yes, ma'am.
Okay, and she stated that those injuries came from the defendant hitting her, correct?
Yes, ma'am.
Okay. And did you speak with the defendant during your investigation?
Yes, ma'am. I did speak with the defendant. Did ask her, how did the injuries get on her daughter, and she admitted to doing it.
Okay, so she admitted, so the defendant, Ms. Johnson, admitted that she did make physical contact with her daughter.
Yes, ma'am.
Okay, no further questions for the witness, Your Honor.
Okay, Attorney Kim.
Yes, Your
Your
Honor.
witness.
Officer, I believe you had testified earlier that you had came to this location twice. Is that correct?
That is correct.
Okay, for the first time you came, you encountered Miss Anderson, who I believe is the alleged victim, correct?
Yes, ma'am.
At the time, did you observe any visible injuries to Miss Anderson's face or anywhere to her body?
At the time, no, sir.
So you did arrive to the incident location a second time due to a property check. Is that correct?
Yes, sir.
Could you explain what you mean by property check?
So property check this label pretty much. I just came there to see what was going on. Call came in, and it was kind of just to see what was up, what was going on there, if there was any issue at all.
Do you recall who had called the police?
I do not recall, sir.
Okay. So what you're saying is that you have received a dispatch in regards to, I guess, just the well-being check?
Correct.
Okay. So when you spoke with Miss Anderson, she advised you that there were minor children that were present during the attack. Is that correct?
Yes, sir.
Okay. Did you speak with those minor children to get, account of what happened based on their side of the story?
Yes, sir. They went, in the presence of the mom and stuff, and we just asked like what if they saw what happened. They were like, yeah. They tried to get her off.
Okay. Do you recall how old those minor children were?
No, sir.
Was it 1 or 2 or 3 children, or?
If I recall correct, I want to say it was 2 kids.
Okay. So you don't know their age, but you say that they're minor children, correct? That they were minors?
They were minors, yes, sir.
Okay. How would you know that if you don't know their age?
I mean, we're looking at them. They were young, fairly young kids, somewhere in there. I mean, from what I looked like, what I observed, I mean, they look somewhere like 12, 14, maybe some 12, 10, 12, 13, somewhere in that age range. That's what it looked like.
You're not quite sure exactly what their age was, correct?
I can't recall at the moment if I did 100% ask the mother the age, but I mean, they look like minors. They were minors.
Okay. It would be an important thing that you would, ask them, right, in regards to, you charging, Miss Johnson with the cruelty to children. Wouldn't that be something that you would want to find out?
Yes, sir, 100%. At the moment right now, I can't recall if I did gather the ages from the mother or not. I can't recall.
Okay. Do you recall, you had testified saying that Ms. Johnson had told you that she admitted to attacking the alleged victim. Did she say anything else?
I remember she was making accusations to the fact that the daughter does drugs or something to that effect.
Okay. So when you observed the alleged victim, Miss Anderson, you noticed that she had a blackened eye, busted nose, and swollen face. Is that correct?
Yes, sir.
Okay. Did you take any photographs of that injury?
Pictures was taken, yes, sir.
All right. Do you believe Miss Johnson may have had any medical or health, mental health conditions at the time?
At the time, the daughter stated that she does have some issues going on. Miss Johnson herself stated she has nothing going on. And this kind of goes back to that first time we went out there. Because the daughter did say that she has some mental stuff going on. She was in one of her hazes, I guess, and was aggressive and loud. And we and EMS actually showed up and they tried to do a little, I guess, an assessment of her, and they deemed her that she was fine. And Ms. Johnson herself stated she was fine. She had no issues going on.
Okay. Did you observe any injuries to Ms. Johnson?
There was but I seen there was a scratch. I remember there was a scratch. She had a scratch, yes.
Where at?
I can't quite recall where it was, but there was a scratch. The picture that was taken.
Of the client, correct? I mean, of the defendant, correct, Ms. Michelle?
Correct. Correct.
Okay. All right. Thank you, officer. Your Honor, I don't have any further questions.
ASG Baker, any redirect?
Just one. You stated it was 2 minor children, officer.
Yes, ma'am.
And did you determine that they were minor because they did not look like they were over 18 years old?
As I explained earlier, I can't recall if I 100% talked to the mother and got the ages, but I mean, granted, as far as right now, for what I'm recalling, they didn't look nothing over 18 years old.
Okay. And as you testified earlier, the defendant admitted to hitting the victim.
Yes, ma'am.
And you saw the victim at a previous encounter with her, correct?
Yes, ma'am.
And at that time, she did not have any injuries?
No injuries whatsoever.
However, when you came into contact with her a second time after both the victim and the defendant admitted to the defendant hitting her, she had injuries on her persons?
Yes, ma'am.
Okay, no further questions for the witness, Your Honor.
Okay. Okay, do you have any other witnesses, ASG Baker?
No, Your Honor.
Okay, Attorney Kim, any witnesses?
Nothing from defense, Your Honor.
Okay, we're ready for argument. ASG Baker.
Reserve, Your Honor.
Okay, Attorney Kim.
Yes, Your Honor. Based on officer's testimony, he had testified saying that he is not aware of the exact age of the children that were allegedly there to observe the incident. Officer testified that he's not quite sure whether they're minors or not. He made that observation solely based on what he saw. However, he did not make any efforts to determine whether those children were minor or not. So for that reason, Your Honor, I'd like to ask the court to dismiss the cruelty to children warrant against Ms. Johnson. Other than that, Your Honor, nothing additional.
Okay. ASG Baker.
Yes, Your Honor. Although the officer did not inquire into the exact age of the children, he did state that the children looked like they were between the ages of 10 and 14. And it is his testimony that he believed them to be underage. In addition to them still living in the home with their mother at the time, it is the state's opinion that we have proven that they were minor children. And they are minor children, and that is the state's case, Your Honor. We ask that this case be bounded over to state court.
Okay. So noted, based upon the evidence presented to the court today, I do find sufficient probable cause to bind over the charge of battery, family violence, as well as the cruelty to children charge against Michelle Colette Johnson. That will be the order of the court today, and that will conclude your preliminary hearing for today, Ms. Johnson. I want to thank both parties for their presentation of their case. Thank you. Okay, the next case on the calendar is at position 21. I have the state of Georgia versus Gabrielle King. ASG Baker, you stay ready.
At this time, the state would ask for a one-time continuance. Our officer is not present at this time.
Okay. Do you have any objections to a continuance, Attorney Harvey Williams?
No objection, Your Honor.
Okay, would 2 weeks be sufficient?
Yes, Your Honor. Is that
the 31st, January 31st?
Mm-hmm.
That'll be my next calendar.
Thank you.
Okay, so January the 31st. So Tina, we're going to continue that case until January the 31st, and that's at position 21, 22, 21 through 22.
Yes, Your Honor.
Okay, thank you. Okay, moving right along, we have position 23 on the calendar, the state of Georgia versus Jarrell Markel Lee. State ready?
No, Your Honor, we are not. Our officer is not present and we have been unable to make contact with her.
Okay, and who's the officer?
Officer Williams. Let me find the exact name. Williams. Theodore Williams. Your Honor, that is the officer.
Are you planning to make contact with him, I guess, on some basis if the case is continued?
That is the plan, Your Honor.
Okay. Okay, do you have any objections, Attorney Kim? This is
Yes,
your.
Your Honor. We'll be requesting we'll be asking for we'll be making an objection in regards to the continuance.
Okay, and what's the basis for the objection?
Your Honor, this is a case that's nonviolent. It's a public drunk. The state was aware that, there was a preliminary hearing that was supposed to happen. It appears that the state was not able to get, the case prepared in anticipation for the preliminary hearing. Additionally, this case was continued till January 31st, Your Honor. It would negatively impact my clients as he will be held in jail pending the new continuance date. So based on those reasons, Your Honor, I'd like to request that the court deny the state's request for continuance.
Okay. Would you like to respond to that, A.S.G. Baker?
Yes, Your Honor, we still ask for a one-time continuance to contact the officer.
Okay. According to Attorney Kim, you said it's been continued from a previous calendar. What is your knowledge of that?
Well, I
Which
just
case,
heard
Your
that
Honor?
today.
Is that Lee, Your Honor?
Yes, and it appears that the officer was contacted on January 12th of this year. So we have made contact.
Your Honor, if the court is inclined to dismiss, if it's Lee, if the court is inclined to dismiss for warrant of prosecution and the state has no objection, it's completely within the court's discretion.
Okay, let me see. Let me look at the warrant real quick again.
I believe it's public drunk.
Mhm.
And I think statutorily, honestly, I believe that offense only requires a fine, and I believe he's been in custody well over 24 hours.
Okay. Give me 1 minute. Okay, after reviewing the WAA and a lot of the defense counsel objections, I will dismiss that case for warrant of prosecution. And that will be the order of the court today. I'll issue my order today as well with respect to dismissal.
Thank you, Your Honor.
Thank you, Your Honor.
Uh-huh. Okay, the next case we have on the calendar is probably a good time to take a break. I know that Solicitor Brooks had asked for a did you ask for a pretrial conference with respect to Malaysia Morris?
Just needed some clarification from Ms. Harvey Williams.
Okay, so you want to go and break out room number 1?
Yes, ma'am, that's fine.
Okay.
Yes, ma'am. Your Honor,
Yes.
I did have a question on the Lyons case. That case was reset to January 23rd. Is that right?
Yes, on the felony calendar.
Okay. Officer Montgomery, I believe, was on that case. And so can he be?
Yes, I'm sorry, we didn't address that earlier. Yes. Officer Montgomery, you're free to go. You don't have any other case on the calendar, do you?
No, thank y'all. Y'all have a good day.
Okay, thank you. Can you go back into breakout room number 1? Or do I need to send you another invite?
I think I can go back in here. Thank you.
Okay, and then Ms. Harvey Williams, can you go, you was in a breakout.
It says
room.
number 2. It's showing up 2.
I'm gonna send you an invite for 1.
Okay, all right.
Okay, thank you. I just sent it. Did you get it?
It looks like she's frozen. Yep, she did.
Okay. Okay. Shay Brooks, I sent her to breakout room. Okay, thank you. Okay, we'll be in brief recess.
Oh, okay.